Is adjustment of status over? That is the question that we want to talk about today. I know this bombshell news just dropped on May 21st, yesterday. Let's talk about that, right? I'm Joseph Zhang. I'm an immigration law specialist here in California, and we spend a lot of time dissecting these memos. So these are the top 11 things that I'm thinking about when I saw this memo. Number one, this memo does not address the backlog that is with USCIS. And that is one of my biggest grievances with anybody who's not transparent or honest. It's okay if USCIS comes out and say there is a huge backlog, they would like more cases to be processed by the consulate. That is fine. But if there is a huge backlog and then they suddenly come out and say, and they reinterpret what the courts have been doing and they change the entire business practice of immigration that's been done for decades, I feel like that is not forthright. Number two, by making all green card applications done overseas, it gives the government a lot more power, it gives the executive branch a lot more power, and it reduces the rights and responsibilities and privileges of Americans. A company trying to petition somebody abroad, a family member who got married, petitioning their siblings. If all of that has to go through the consulate, if the executive department can control what the consulates do, they could just completely stop processing of all these immigrant petitions. And even if they don't pause it, if there's denials, there's non-consular reviewability, and you cannot sue, you cannot appeal, it's all up to the consulate. So in this situation, the people's power, the corporation's power is drastically reduced, and it becomes much more political. Is that what we want our government to be? Number three, this outsources a lot of jobs overseas. Now, we know the consulates have been expanding over the years, especially the one in Mexico. It's like rebuilding, it has a big new office, and they're gonna hire a lot of people. But a lot of the people that they hire, the IT support, the cleaning staff, a lot of the support are all overseas. And those jobs originally were in the US. If USCIS doesn't need to adjudicate so many green card applications, they no longer hire, they continue to furlough more people, it downsizes, and they outsource everything overseas. Again, is that good for America? Number four, I've heard the argument that consular processing is much more safer and secure with more detailed background checks. And in the US, adjustment of status arguably doesn't have as detailed of a background check. As a practitioner, it's about the same. In the US, when you have these green card interviews, you're at least in a private office with an officer that reviewed your case and it goes in detail reviewing the individual in front of them. Overseas, it's in that giant big room. Less privacy, much faster, right? Having gone to visit many consular officers, a lot of these consular interviews happened within a few minutes. But routinely in the US, it is much more sophisticated, much more detailed. And for a lot of the officers who are in the United States doing these reviews, they are much more seasoned because USCIS officers are generally career officers that have been here for a long time, whereas consulate officers, they're there for 2 years and they move to a different post. They're relatively new. They're sometimes in their 20s. So I don't buy the argument that consular officer review in applications and immigrant petitions are much more thorough overseas. Number five, what's going to happen with the K-1 visa, right? The whole idea of the K-1 visa is to come to the US, get married, and file adjustment. If the adjustment of status is meant for extraordinary circumstances, then what do? You fly here, get married, and you file the I-130 and go back to the home country and wait for the NVC and consulate? That doesn't make sense, right? No one will do K-1 anymore. Number six, last year there's a new memo that added discretionary review under all change of status applications. Essentially saying even if you qualify in every way, shape, or form, it is still discretionary for the officer to decide whether they want to approve your change of status. This memo, in so many words, essentially does the same thing, but now with adjustment of status. But they didn't just say it is now discretionary, because it has always been discretionary, right? It's never been non-discretionary, but they somehow heightened it to saying that it is now extraordinary, right? It's an extraordinary benefit to get a green card. Therefore, adjudicating it in the United States is an extraordinary event. And so you have to have an extraordinary feat to persuade the officer that they deserve to get it. This puts additional burden of proof on every applicant and every law office, not only just to put adjustment status application together, but to argue this very vague standard of why are they doing it in the United States and why they're not doing it overseas, and what extraordinary circumstance is causing them to have to file this. This is just a lot more work on everyone, including all the USCIS officers who are still adjudicating cases, because now if they deny a case, now they have to write out all the reasons why they're denying it. Number 7, interviews are going to be far more important now, because every single interview, essentially, you're going to have to bring this up, that this is an extraordinary case. For the past 20 plus years, our firm has always maintained the stance that if it's a good, clean, easy case, you don't necessarily need to spend that extra money to hire an attorney to go with you to the interviews. But going forward, these interviews are going to be so much more important because of this new standard. Because these interviews have such a high stakes now that you have to now not only present that your case is great and good and approvable, but you also have to persuade that it's extraordinary. And that takes now actual deep representation. Number 8 is that non-immigrant visas is going to be much more important. I think one of the biggest impacts of this particular memo and policy is that it's going to extremely dissuade and discourage people coming in with ESTA, visa waiver, people coming in with tourist visa, and then just immediately filing for adjustment. Or people who get paroled in very temporarily, short, like within like a few months, and then filing for adjustment of status. I think those type of cases are going to be much more difficult to argue why this was extraordinary, why they couldn't do it in a home country, why isn't this just solving an inconvenience problem. So it's going to force a lot of people to do a change of status, get the F1, get the H1B, get the L1, get the things that with, maybe with the O1 as well, get visas with dual immigrant intent, and then argue that your job, your project is so important to the US economy, to the employer, to individuals, to citizens, that if you had to stop everything and leave for even a few months, it would be an extraordinary suffering. And so non-immigrant visas become that much more important. Number 9, I don't foresee the adjudicating time of adjustment of status to actually shorten because of this. Again, we have over 11 million case backlog. Even if we don't get any new cases, it will still take years to kind of work through everything. I don't foresee the time process becoming shorter because there's so many new things that a USCIS officer is supposed to do that they don't even have the time to do. They're supposed to re-adjudicate a lot of the adjustment status applications that was filed in the Biden era. They're supposed to be doing a lot of in-depth business immigration interviews as opposed to just family interviews. So there's so many things that they have to do with the backlog. Again, too many things that they're supposed to do. By doing this memo, it decreases the number of adjustment status case filings, but with the ones that are still filed, they have to do more work to adjudicate it fairly, to do their job, because now when they adjudicate a case, they have to look at the totality of the circumstance and not just they meet the basic requirements of an adjustment of status. So I don't foresee cases being faster. I think it's going to take just as long, if not longer. And I think this is for here to stay until AI picks up and somehow that makes things a lot faster. Number 10, if there is a significant decrease in the adjustment of status applications and USCIS is 99% funded by our filing fees, are we going to see a premium processing application for adjustment of status? Are we going to see that tied to advanced parole? Are we going to see that tied to 765 work authorizations? I don't know. But if a lot of people are not going to file adjustment status in the US and there's a lot less revenue, the thing that USCIS has always done is just increase fees. And one of the things that they're increasing the most is just attaching premium processing to everything that they want to make money on. It's just going to be that much more expensive. Number 11, the 485 adjustment of status plus the 601 waiver combo might be history, right? Because for a lot of people, if they have a fraud and misrepresentation, if they have certain problems with their application, at least in the past 4 or 5 years, we've seen a lot of 45 applications filed. There's a problem with it. During the request for evidence, you prepare a 601 waiver application, you submit it, both of them gets adjudicated by the same officer, approved, and the applicant can still get a green card. That's so good for so many people. But if they no longer can do this, that means they have to go overseas to apply for the green card, get denied, and file the 601 with USCIS and have it adjudicated, and then go back to the consulate to get approved. And this adds additional potentially 3, 4, 5 years to something that was done within a few months. There's just a lot of uncertainty, but despite all this, I know that you know that USCIS within this short time is probably going to be business as usual, because this memo comes out from the higher ups. It's a national memo, but local USCIS officers are still adjudicating things according to their directive immediately. But what's going to happen 3 months from now, 6 months from now, right? And so I just want to encourage everybody, kind of share what you're seeing, help each other out, and wish you guys all the best. Okay? Take care. Bye-bye.